I'm Dan Johnson. I'm from the Stamford office, and I'm going to be speaking this morning about the tax consequences of modifying or decanting trusts. When I was thinking about this presentation, I was thinking about how things have changed in my career. Obviously, the most dramatic change is the change in the exemption from the estate tax. It's 13.61 million today. It's going to be 13.99 million on January 1st. When I started practicing, it was $600,000 per person. So this was a tax that really had an impact on every middle-class family in Fairfield County that owned a residence. The second biggest change in my career is this ability to decant or modify trusts. This idea that you can set up an irrevocable document and then you can come back to it and figure out ways to make changes to it. And so there's this Irish saying by an author named, well, it's not by him, but he made it popular. Maurice O'Sullivan wrote a book called 20 Years of Growing. And it's based on the spectrum of a person's life. And so the saying is 20 years of growing, 20 years in bloom, 20 years of stooping, and 20 years of dying. And so I'm halfway through my stooping phase. Most of the speakers today are still in bloom, thankfully. I'm having that middle-aged person's realization about how much things have changed during my career. And the chilling thing I can say for the associates are, when I started at Cummings and Lockwood, I had never been on the internet. And in fact, it would be several years before I'd used the internet for the first time. I did not own, nor had I ever used a cell phone. When I was driving around and meeting with a client, I had a map of every street in Fairfield County in my car, and you would find the street on an index, and then you have to flip to the map and figure out how to get to that street from either the Merritt Parkway or 95. And then finally, if I had a friend who was flying into town, I could go to the airport and meet them at their gate to pick them up. And to get to the gate, I did not have to take off my shoes. So you get the point, which is I've been around for a while and things have changed a lot, but I want to take you back for a minute to my first day at Cummings and Lockwood, September 9th, 1997. And I was showing this picture to Doug Olin, my partner, and he said, I can't believe it. You look exactly the same. There must be some kind of fountain of youth in the Stamford office. The New York decanting statute, which was the first decanting statute, was 5 years old when this picture was taken. It had been revised for the first time in 1995. And so I just want to take you ahead a couple of years to 2004. And so in 2004, we have a revenue ruling, and it's based on a very common trust. This is a grantor creates a trust for the benefit of his family. The trustee is required to be an independent trustee in this trust, and it's a grantor trust for income tax purposes. And all that means is that the grantor is responsible for paying the income tax bill on behalf of the trust. And so a couple questions in this revenue ruling. One is, when the grantor makes that income tax payment on behalf of the trust, is that a gift to the beneficiaries of the trust? And the second is, if that trust includes a tax reimbursement clause, is that an estate tax issue for the grantor who might be reimbursed? And so the IRS said, we're going to take this question, we're going to break it down into three different situations. The first situation is that the trust has no obligation to reimburse the grantor for income tax payments made. It's grantor trust for paying income taxes, but the trust is not required either in document or by statute to reimburse the grantor. The second situation is that the trust document or statute requires that the grantor be reimbursed. And the third situation is that the trust document permits the grantor to be reimbursed at the discretion of an independent trustee. And so the IRS looks at this and they say, well, the gift tax consequence of the grantor making the payment on behalf of the trust when he pays the income tax bill on behalf of the trust, that's an easy one because this is a legal obligation that falls on him. He has to make this payment. And so there's no gift tax consequence when he makes that payment. So in all three situations, that's the same. But the question about whether he has an estate tax issue depends on each situation. So in the first situation where he's not entitled to any reimbursement, of course, there's no retained interest under 2036, and so there's no potential estate tax inclusion for the grantor. In the second situation where he is required to be reimbursed, again, this falls squarely under 2036. He has retained an interest in property that he gave away, and so he has an inclusion issue under Section 2036, so a major estate tax problem. The third situation is probably the most intriguing to us as estate planning lawyers because this is the one where he can be reimbursed when he makes an income tax payment, but it's at the discretion of an independent trustee. And in this case, the IRS says, that's okay, no estate tax problem, because neither the grantor nor the beneficiaries are controlling whether or not he gets reimbursed. So there is potential access to the trust assets, but he's not controlling that access. An important aside that I'm going to come back to is the IRS also says, no gift by the beneficiaries to the grantor. So assets are leaving the trust at the discretion of an independent trustee. And the IRS says that's no gift by the beneficiaries of the trust back to the grantor of the trust because, again, they're not in control of that decision in the hands of an independent trustee. So this is one of those neat revenue rulings that you can throw out with your clients if you're having a conversation about grantor trust, because there's always that question of, I'm paying taxes on behalf of this trust that's funded with assets that I gave away. When I pay those taxes every year, it kind of feels like a gift, and it can become a really powerful gift over time. Why isn't it a gift? And now you can say, oh, that's old Revenue Ruling 2004-64. The other thing is, this sets the stage for the feeling amongst estate planning lawyers saying, it seems to stand for this proposition that if there's a reimbursement provision, but that reimbursement is controlled by an independent trustee, I don't have to worry about the potential of the beneficiaries making gifts back to the grantor. So I'm going to skip ahead to 2016, and this is a private letter ruling. And we're looking, in this case, at actually modifying a trust. So this is a traditional gifting trust. Again, it's a grantor trust. It has an independent trustee. And the independent trustee is applying to modify the trust to include a tax reimbursement provision. Why is the trustee doing that? Because the grantor says, this is directly from the private letter ruling, due to unforeseen and unanticipated circumstances, payment of tax on trust income has become unduly burdensome. That's just the call we all get from our clients saying, this tax burden has become not I'm paying too much, or this is a pain in the neck, or it's killing me. It's become unduly burdensome. And so the modification seeks to add a trust reimbursement provision into the document. And in this private letter ruling, the IRS says, that's okay. This proposed modification, it's administrative in nature. It's not changing the beneficial interest in the trust. And so there's no gift tax consequence here. So now we feel like we've got it under control. We've got this 2004 revenue ruling. We've got this 2016 private letter ruling. And so estate planners feel like we know how to avoid taxable gifts when we're looking at a trust modification to add in a tax reimbursement provision. So we get to this chief counsel advice in 2023. And the facts of this case read a lot like the facts of the private letter ruling that I was just discussing. You have a successful grantor trust, you have an independent trustee, you have a petition to add a tax reimbursement clause. One important fact that I'm going to layer in this instance, the petition had the consent of all of the beneficiaries of the trust. So they knew exactly what was going on. They were signing off on it. And so based on what we've learned so far, we say, well, this seems a lot like the 2016 private letter ruling. This is a change. It's a proposed change to an existing document, but it's administrative in nature, and we're not changing the beneficial interests of the trust, so it shouldn't be problematic. And the reason the estate planning world was upset about this was because we got a surprise result. The IRS said, when you make this modification to the existing trust to add in the tax reimbursement clause, the consent of the beneficiaries results in a taxable gift. They actually signed off on this before the independent trustee did it. And then they add in something that's even a little bit more interesting. They say, by the way, even if they hadn't consented, just knowing that this was happening and not objecting to it, if they had notice of it, but they didn't take advantage of their opportunity to object, that would also be a taxable gift. And so the taxpayer says, well, what about the 2004 revenue ruling? And the IRS says, this is different because in that case, the beneficiaries didn't consent in advance to the reimbursement. And what about the 2016 private letter ruling where, again, this is administrative in nature, we're not changing the beneficial interests. And the IRS says, you're right, that private letter ruling is directly on point, but the most chilling thing a lawyer can hear, it's no longer reflects the position of this office. So the estate planning world goes bananas. And you have Jonathan Blattmacher, who's one of the best known and most well-respected trust and estates commentators, starts giving a seminar saying that this 2023 chief counsel advice is one of the 10 most important developments of the last 10 years in the estate planning world. And people start to point out, deficiencies in this chief counsel advice. I would say the one that resonates with me the most is the idea that when the beneficiaries agree to put a tax reimbursement provision into a trust, by doing that, they're preventing something else from happening. I mean, there's another escape hatch for a grantor who doesn't want to pay tax on behalf of a grantor trust anymore, which is turning off the grantor trust status of that trust. Now, if you do that, we know the trust is going to pay its own taxes going forward. That also means we can't go back. We can never create another situation where the grantor is able to pay taxes on behalf of that grantor trust again. That's a one-time toggle when you turn off grantor trust status. And so instead of making a gift when they acknowledge or when they sign off on a tax reimbursement clause being added to an existing trust, aren't the beneficiaries really acting out of their own self-interest, saying, let's give this grantor an escape hatch where they can be reimbursed, which is what would happen if we turned off grantor trust status. The trust would pay the taxes. So that's a trade sideways. But at least with a tax reimbursement provision, I'm leaving open as a beneficiary the possibility that if the grantor wants to, if he regains the ability to pay taxes or for whatever reason he wants to pay taxes again during his life, that door is open through a trust reimbursement provision. The other things that commentators were talking about, a lot of them are variations of the valuation issue. Let's say for the sake of discussion, I'm advising a client and I say, you're going to be signing off on this affirmatively, this addition of a tax reimbursement clause to the document. The IRS seems to be thinking that that's taxable gift. So why don't we report it on a gift tax return? We'll satisfy the adequate disclosure regulations. And then after 3 years, you don't have to worry about this anymore. So we go out and we hire an appraiser and they start asking questions saying, well, how many beneficiaries are there? And what do we do about the interests of the contingent beneficiaries? And how often is this clause going to be taken advantage of by the grantor? And the point of all those kinds of questions is, how do you appraise this interest? Is it even possible, if you wanted to protect yourself and file a gift tax return, is it even possible to get an appraisal of this kind of a gift? And then the last thing is this idea that you could be making a gift as a beneficiary of the trust by receiving notice that this kind of a change is happening and not doing anything about it, not raising an objection. I guess the thought there is, what if I'm a beneficiary of a trust and I get a notice from a court saying, we're going to make this change to the trust. It's administrative in nature. It's a tax reimbursement provision. And this notice is Greek to me. I don't know what a tax reimbursement provision is. I haven't paid any attention to the administration of the trust. I'm not inclined to hire a lawyer to help me figure this out. So I just do nothing. Do I have donative intent? Am I really making a gift under those circumstances by not doing anything about something I don't understand? So you can kind of hear in all of those arguments that the trust and estates world is kind of panicked about this chief counsel's advice. And one of my favorite writers, who he writes about other things, but he wrote about football as a hobby. His name is Greg Easterbrook. And he used to write this column called The Tuesday Morning Quarterback. And he had this saying, it was the first rule of panic. And the first rule of panic is don't panic now. There's plenty of time for that later. And so the question is, are we falling under the first rule? Are we panicking about this decision, or are there reasons to not be panicked about it? And one reason to not be panicked is because of what a chief counsel advice is. So a chief counsel advice is basically a brief associated with a specific set of circumstances. That is, this is the IRS making its strongest possible case relative to facts and circumstances that may not be fully on our radar when we read the advice. I mean, there could be some very aggressive planning lying behind this analysis. It is, however, as Steve Gorn said, it's a shot across the bow. It's the IRS saying, here's where we're headed on this particular issue. And so you should know, although this isn't binding authority, you should know that this is what this office is thinking about potential gifts related to modifications of trust. So what do we, as practitioners, do about this? We try to prevent beneficiaries from having involvement to the greatest extent possible, whether that's putting it in our documents or using the most favorable state law that we have access to. Some of the changes that we might be making through trust modifications or decanting, can they be made using a power of appointment, the kind of the old-fashioned approach when I started practicing, using a surviving spouse's power of appointment? Of course, like any issue where what's going to happen in the long run is uncertain, we owe a duty to our clients to tell them about this. And if, it's a really big transaction and they want to be really conservative, they can consider filing a gift tax return and saying that there was no gift or there was a minimal gift to satisfy the adequate disclosure rules. While we're kind of in the neighborhood of decanting and modifying trust, I did want to quickly touch on something that really is probably its own topic, but would be too much for a seminar like this, and that's GST considerations related to decanting. And what I'll say here is the good news on this front is there's a couple of safe harbors if you're decanting a trust that's GST exempt. If the authority comes from either state law or the trust, and you don't need the consent of the beneficiaries, and you're not extending the rule against perpetuities, that's safe harbor number one for decanting a GST-exempt trust. Safe harbor number two is you don't have authority in the trust document or pursuant to state law, but you're not shifting beneficial interests, and there's no extension of the vesting of beneficial interests. Safe harbor number one is kind of the more interesting one because it does allow for potential shifting of beneficial interest. So that's a more flexible option if you have the right authority in the document or under state law. When I was thinking about this and during Dan's presentation, one of the things that occurred to me is most of the decanting that I've seen was either to take advantage of an income tax planning opportunity or for asset protection purposes. So a lot of times we're actually not doing much with the dispositive provisions of the trust. I personally have never done anything about like changing beneficiaries. I mean, I guess sometimes we've been changing trustees. The point is, I think as practitioners, as advisors, you want to know when you're doing a potential decanting, are we doing anything that potentially changes the interests of the beneficiaries where the GST consideration deserves a hard look? I wanted to, in light of my kind of concern about the IRS and how they're looking at attempts to alter trusts, I wanted to leave you with a case that I found chilling, at least when I read it. This is a traditional but very valuable Q-tip trust, in this case, McDougall versus Commissioner. You can see it's only a couple of months old. So you have a surviving spouse, 2 adult remaindermen, and the planning here is we're going to terminate the trust, again, with the consent of the spouse and the adult remainderman. So we're going to distribute all of the Q-tip trust assets out to the surviving spouse. The surviving spouse is going to take those assets and sell them to the adult remainderman. So kind of like an installment sale, but outside of a defective grantor trust. And the hope is that the growth of those assets will exceed the interest rate on the note that's used in connection with the sale. And so the IRS gets this case into the tax court and they say, well, surely when this trust is being terminated with the consent of the current income beneficiary, it's a Q-tip trust, so has a guaranteed income interest for the rest of his life. Surely that's a gift to the remainderman when he gives up that interest. The tax court says, we've been down this path with you guys before in the estate of Annenberg, and so the analysis is the same. Get out of here with that argument, ruling the same way. That's not a gift by the spouse. But the IRS says, well, we have another argument, which is when the remaindermen consent to the termination of this trust and the distribution of all of the assets to the surviving spouse to accommodate this planning, that's a gift, because aren't they giving up a fixed remainder interest in the trust in exchange for nothing? The trust assets are leaving to the surviving spouse, and we know that the surviving spouse is going to do some planning involving the sons, but there was no guarantee that that would happen. The surviving spouse could take those assets, redirect them to other people or charities or other institutions. And so the tax court says, you know what, you're right, that's a gift. And so the ruling in this case, it was tens of millions of dollars of gift tax liability for these 2 sons. It's under appeal in the Ninth Circuit, and there's valuation issues that have to be investigated. But it's a chilling. I mean, I'm sure many of us in this room, most of my partners at some point have terminated a Q-tip trust. And how many of us would think about a potential gift tax consequence if the remaindermen were directly involved? So my cheery holiday message heading into 2025 is you should know that the IRS is very focused on potential gift tax consequences of estate planning involving trusts. And so whether you're doing something kind of exotic, like adding a tax reimbursement clause to an existing trust, or something kind of, what we thought of as mundane, which is terminating a Q-tip trust and distributing the balance of the assets to the surviving spouse, we should be thinking about potential gift and generation skipping transfer tax consequences and coming up with the way we want to approach them with our clients. So thank you very much.